issue of gunshot wounds in the case law that emphasize that normally they are not especially heinous, atrocious, and cruel. So I submit there is no evidence she knew she was about to die, no additional acts presented. That's just the evidence. That's where we are. No evidence he intended to have her suffer or inflict a high degree of pain. Plus, the medical examiner also testified there were no defensive wounds, and that is important as well because some of these cases talk about that as, of course, contributing to especially heinous, atrocious, and cruel. Judge, the evidence is just not there. Again, if this is found to be EHAC, then every single shooting will be. Thank you, Judge.
Can you distinguish on page 29 of that Gonzalez case where the court mentions that the victim's mental state, let me find it right now, and the victim's perception of imminent death need only last seconds for the aggravator to apply?
Well, that's one thing the court is saying. If that's what they're saying in Gonzalez, and I saw that in Gonzalez, sure. That's not saying, oh, that means that it only means that. That's one quote by the court in that the victim knowing. So in other words, it's kind of similar to, as I mentioned, the Jimmy Rice case, where the guy, Mr. Chavez, has the gun, and he says to the victim in a few seconds, do you want to die, or you are about to die? So that is just I don't necessarily disagree with that. That is just a quote in Gonzalez about the time period in which the victim felt the apprehension.
So your argument is in Gonzalez, all the other factors in conjunction with the time makes the difference.
Oh, absolutely, absolutely. Because if the Florida Supreme Court is making that one-line quote in Gonzalez saying that period of time can be a few seconds, okay, that's what they have stated by saying that. But in Gonzalez, that is the one where you have the shot into the floor, you have the shot into the leg, you have the shot into the other leg, and you have the victim terrorized. Gonzalez led that person into the bedroom. So if all of that is happening quickly, so that is just one line in it. They're making that comment that, hey, that apprehension and the victim being aware could just merely last seconds. But again, that is only one of the factors. We have to look at Mr. Walker's intent to cause unneedless suffering. This has to be wicked, shockingly evil, or vile, that he designed to inflict a high degree of pain. So we're not just looking at Miss Alexander, even in those few seconds. That is just one line in Gonzalez. Again, there has to be additional acts to show it was conscienceless and pitiless and unnecessary torturous. So Mr. Walker is there evidence that he has utter indifference to or enjoyment in the suffering of others? That issue of just a few seconds, and I don't necessarily disagree with that one line, and of course it doesn't even apply in Gonzalez because of what happened. But that's just one part of it. And honestly, we don't even know. The thing with this case is you just don't know. So no, yes, Judge, that is clearly distinguishing.
Judge, just one thing I point out, she keeps saying heinous, atrocious, and cruel. Is heinous, atrocious, or cruel? We don't have to prove every single one of those things. And the fact that she knew of her impending death is a super strong indicator of cruel, Judge. And we believe these cases are not really that distinguishable. In each of these cases, a victim is shot once and then moments later executed, similar to here. And the courts are finding that those situations in which a victim is shot once and then later shot again, a short period of time later, that's heinous, atrocious, and cruel. That's what we have here, Judge. I agree, if we could not establish the sequence of the order, we would probably not have alleged this particular aggravator. The fact is, we can prove the sequence of the orders, and we can prove that the first shot she received was not a fatal shot. She was alive, she was in fear, she was in a place she had no idea where she was, because she'd been taken there by this man. She gets out of the car, she walks away from the car, so clearly has ability to move, knows what's happening, and clearly knows death is right around the corner from the man who just shot her and is now getting out of the car himself. So all of that, Judge, is consistent with all of these cases in which you have an individual who was shot and then mere moments later executed, and the courts have found that the knowledge of the impending death is what makes it AJC. So that is why we believe this case does qualify and it should be a question for the jury.
Let me ask you this, Mr. Terry. I'm going to find this Rivera v. State at 545 Southern Second, 864, Florida Supreme Court. In that case, an officer of the law was murdered. 2 shots were fired within 16 seconds of each other. And despite the fact that the officer was shot while kneeling on the floor with his hands upraised, the court found that that was not hack. So how do you reconcile that with Rivera without recognizing the fact that in Rivera, the victim had witnessed her husband or her significant other being shot twice and then executed before she was shot? So while the court may say mere seconds, but there was quite a history before the second victim was killed in Gonzalez.
In that case, Judge, he was shot and killed pretty much instantly. In the case you're.
But if you look at
with the law enforcement officer.
If you look at the language preceding the line on that page where it talks about only mere seconds is fine, and it talks about the common sense understanding of witnessing someone getting shot twice and executed had some effect on that victim as well, mere seconds, but it's not, I don't think it's taken in isolation. And it's hard to.
And I agree, Your Honor, there are cases, we could sit here all day and go back and forth on cases because
Right.
it is such a close call. But one of the things that I believe the courts take very seriously is this knowledge of impending death. And I'll go back to Phillips v. State, in which this individual was stalked. In the same sense, quite honestly, our belief is, Nilexia Alexander was stalked by this individual when he was looking around trying to find her, okay? It shot twice in the chest and then fled a short distance before being killed by repeated shots in the head and neck. I don't see how we can distinguish this case from that case.
And which case is that again?
That's the Phillips v. State case, Judge, 476
Phillips.
Southern Second, 194.
Okay.
And it says, the trial court correctly surmised that between 2 volleys of gunfire, the victim must have agonized over his ultimate fate and properly considered the circumstances in the sentencing process. I don't see how it's any different than what the situation we're talking about here. And again, Judge, we could go be pulling up cases literally all day long. I can't tell you how many cases there are on HAC in the state of Florida. And slight little tiny differences will distinguish each one. But one thing that seems to be consistent, especially when it comes to gunshots, is that if there is a delay between the first shot and a fatal shot, that generally will fall under the HAC, almost always, at least everything I've read. And so I tried to pull out some of those cases that I saw that seem to be indicative of that. And here we have that exact same thing as we have in Phillips, where you have a person stalked, they're then shot twice in the chest, fled a short distance, which is kind of what we have here, Judge. I don't see how it's much different. And then killed by repeated shots in the head and back. And again, the finding in this was that the trial court correctly surmised that between the 2 volleys of gunfire, the victim must have agonized over his ultimate fate. And that's the state's position in this case, Judge. Nilexia Alexander was shot, and in those 9 seconds clearly must have agonized over her fate because she knew she was in a horrendous situation and she was going to be killed. And so for that, Judge, we would cite Phillips, and we believe that we have have a case of heinous, atrocious, or cruel.
All right.
Judge, he keeps talking about she knew of her impending death. There is more than that right in the jury instruction. And Phillips, they even said the victim fled 100 feet. So they had the evidence. We don't have that. We don't know any circumstances after getting out of the car. We know nothing.
I mean, honestly though, your assumption that the first shot didn't incapacitate her was based on the blood trail and things, but she could have been removed from the car by Ronny Walker and taken.
That's not what Robert Creed said, Judge. You gotta take the two in concert. Robert Creed's testimony is that she was shot in the car, grabs her chest, ordered out of the car. She gets out of the car on her own volition and walks out by herself. And then he sees Ronny Walker gets out, and then a few seconds later he hears gunshots.
Right.
So what I'm saying is that the physical evidence corroborates what Quincy Creed said occurred. So that's why we're saying have proven that, Judge. It's not an assumption. This is what the state's position is. We have proven that beyond a reasonable doubt.
If I could just correct Mr. Terry on one thing. He said that after being shot, Creed Creed indicated, Mr. Walker said at that point, get out of my car. That is not what the evidence was. It was prior to that. They had the argument, are you having sex? No. Then Mr. Walker says, get out of my car, then the first shot. So I just wanted to clarify that.
Okay, Judge,
Yeah.
that's regardless of that, I'm just saying.
I understand.
She got out of the car of her own volition, her own abilities, and was not dragged out, was not pulled out, was not carried out. She got out and was walking and bleeding, which means the only shot that it could have been was the one to her back.
I understand. All right, so I'm gonna reserve it out for a moment while what is the next issue?
So the next one?
The next issue?
Yes. All right, so my motion also includes cold, calculated, and premeditated without any pretense of moral or legal justification. For the record, I want to read in the jury instruction, and this is 921-161-6I, of course. The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. I'm going to concentrate and leave that part out of the moral and legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. A killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent and the killing. The period of time must be long enough to allow reflection by the defendant, and the premeditated intent to kill must be formed before the killing, and of course, that is the definition for premeditated murder. However, cold, calculated, and premeditated is different. It is a heightened premeditation. However, I'm continuing with the jury instruction. For this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. And then it goes on to, and I will read it into the record, a pretense of moral or legal justification is any claim of justification or excuse that, although insufficient to reduce the degree of murder, nonetheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. So going to the facts presented on that. All right, so I want to take the court back to the compilation video, and if the court wants to look at it again, because I watched it several more times. We have Ms. Alexander, first of all, walking, and of course we know there's no contact with Mr. Walker. We know it is with Mr. Creed. We have her walking in a very, very lit apartment complex. She's looking down at her phone. She has the charger around her neck. Very well lit, to the point that the police have flashing blue lights in that area. We then have her getting into a vehicle. That is also well lit. The car's lights remain on when it is sitting there in this well-lit area, picking her up, lights still on, and prior to that, you see the court drive headlights on. So then she is picked up. The vehicle drove along with, headlights, it's not shutting off his lights. There was testimony that it was only 1.3 miles from the location to where she was picked up to the location off Floribraska and Highland. Now, the video from the corner of Floribraska and Highland, which is the one with might potentially be a spider leg across the camera, the timestamp is off. However, my sequence of discussing it, even with the timestamp wrong, satisfies what I need to talk about. The car is first seen at 2:59 and 21 seconds coming down Highland with its headlights on. The vehicle then turns down Floribraska, still with its headlights on. The car goes down a short distance out of view. We know down there further is a dead end, because that part of Floribraska is a dead end. That car did not sit at this dead end. There has been so much talk about this being a dark, isolated, and desolate area. This is not an orange grove. This is not fields off the interstate. The car goes a short distance, goes out of sight, and must make a U-turn where that dead end is, and comes back. It is not in the dead end. It comes back and parks in front of a lot that doesn't have a house on it. This is a residential neighborhood. This is not some desolate, isolated area. If Mr. Walker planned on murdering her and wanted to murder her, why doesn't he take her off to some field? Why does he take her to a residential neighborhood? He could have sat back in the dead end. He didn't. He made the U-turn and parked in front of where there was not a house for that area. So the headlights at that point do not go out until the vehicle parks there. The vehicle parks there 3:00 and 4 seconds, and again, that's off, but for my purposes, the timing works. 3:00:51, so presumably in that time period, we have the shooting, 47 seconds, as we've mentioned before. The lights then go back on, because the car is now gonna move. It goes back on, the headlights briefly like flicker off, and then they go back on. So 1.3 miles. The testimony, Detective Whelan said it was not far from the location where she was picked up to the scene. The vehicle is never at any time from that video itself at that dead end. He is not. He is more towards the intersection of Floribraska and Highlands. Alan Wallace, who lived in the neighborhood and was studying for the bar, saw the vehicle. He testified that the vehicle's lights were on, and in fact, they were shining into his window, and it disturbed him while he was studying for the bar. His comment was the car was, quote, in the middle of the street. Yeah, it's at the middle of the street, right off the intersection of Floribraska and Highlands, because it went down, made a U-turn, and came back. This is not taking place at the dead end. And it could have been. First of all, you wouldn't take her to a residential neighborhood, and you could have stayed in the dead end. State's Exhibit 36B, the overview of the area, Your Honor can clearly see it's a residential neighborhood. There's houses in the front, there's houses on that road. It is a residential neighborhood. I'm looking just as I'm looking at mine. All right, Eric Walker. There were several people out in the area that night. He heard the shots, he went to investigate. He's knocking on doors because it's a residential neighborhood and he's looking for ring cameras. His testimony, there was a fair amount of people out and about. Officer Abby Pittner from the Tampa Police Department said the area is an empty lot. Yeah, because there's not a house on it, with houses surrounding it. The state called many neighbors who had cameras, because there are all houses on this street. Detective Whelan described the area as, quote, a residential neighborhood. Mr. Creed did not testify, actually said he didn't know Mr. Walker had a gun, so we don't know anything about that. Mr. Creed did not testify to any comments of, I want to kill her, I'm going to kill her, I have this plan, absolutely nothing. What happens is, apparently Mr. Creed arranges to meet her, presumably, because we know it's not Mr. Walker, and there was some comment by Mr. Creed about he was looking for the girl, period. That's it. Not he's looking for this girl to kill her, not looking for this girl to get back at her, not looking at this girl to hurt her. And that's after they were driving around so he could look for a girl for Mr. Creed, presumably, to do something with. So there was nothing said, no threats to kill, just that he was looking for a girl. Where is this careful plan? Where is this heightened premeditation? And we know the argument, and the argument is critical, because when you have the case law and you have the jury instructions, when there's an argument, the argument started over the sex. Mr. Walker, after Nilexia Alexander says no, he says, get out of my car. An argument is frenzy, it's rage, it's impulsive, it is taking place at that moment. That is not cold calculated and premeditated with heightened premeditation just because they picked up Miss Alexander, went only 1.3 miles. I've described the car already, and there's absolutely no other evidence. No evidence of harms or threat to her. Mr. Creed never testified that Miss Alexander ever crouched down. This goes, I guess, to the EHAC argument as well. He never testified that he saw her crouch down and turn to her side, if that, in fact, is what the state will continue saying about premeditation. We've got to have that heightened premeditation. Stanley Wilson. All Stanley Wilson recounts is a conversation allegedly afterwards. Yeah, she gave me an STD. Apparently, I guess that's why he shot her. That's not premeditated. That's something said after the fact. He didn't testify to issues or arguments that Mr. Walker said to him, I'm looking for her, I have to get her, we had an argument. He never testified, or neither did Mr. Creed, or no other evidence, to a careful plan or prearranged design to kill her. There is no evidence in the record, Your Honor, of a careful plan carried out with the heightened premeditation. The jury has found premeditation, but to have the code calculated and premeditated, you have to have that heightened premeditation. What we have is an argument, an impulsive argument, and then an act after that. That does not rise to the level of heightened premeditation. There is absolutely no evidence of that. There was some evidence by Mr. Wilson. They knew each other, okay? That is not a plan to kill. A careful plan prearranged to kill with substantial cool reflection. It just doesn't exist. By the way, there was never any evidence presented. The state keeps saying lured. He lured her to her death. There was not one shred of evidence that he lured her or lured her into that vehicle. Again, as the state did with especially heinous, atrocious, and cruel, they want to speculate. They want to assume. We need evidence. We don't have any knowledge of them communicating. We didn't have any evidence that some comment was made in closing argument, Ms. Alexander could trust Mr. Walker, and that she put her guard down, and because he was, quote, luring her. There's no evidence of any of that. That was pure argument. And again, where we have the vehicle, we have painted this picture of some desolate area. These cases talk about what a desolate area is. That vehicle was parked just short of the intersection of Highlands and Floribraska. Could have stayed at the dead end, but did not. A couple of cases, they pretty much talk about what you have to have for the code calculated and premeditated. Let me, just for the record, and then I will go to Mr. Tick's cases. All right, for example, I cited the Victorino case, 23 Southern 3rd 87. That is an extreme example where the aggravating factors were, of course, shown. I'm sure we're all familiar with the Victorino case. That is the Xbox murders on the east coast of Florida. But the court talks about the enunciated four-part test for the application of that aggravator, and it is the killing being the product of cool and calm reflection, and not an act prompted by emotional frenzy, panic, or a fit of rage. And the defendant must have had a careful plan or prearranged design to commit the murder before the fatal incident. The defendant must have exhibited heightened premeditation, and there must have been no pretense of moral or legal justification. The Wyndham case in my motion, 656 Southern 2nd, 432. It cites the Richardson case. Again, with this aggravator as well, I'm sure Mr. Terry would agree, we could also be here all day long with facts. We don't have the facts and evidence in this case, but it cites Richardson, where they did not find those elements were proven. We just don't have the evidence. I'm checking if there was anything else. Or was it? Okay. So Mr. Terry's cases. Mr. Terry cited 4 cases of code calculated and premeditated without pretense of moral or legal justification. Those cases are extreme cases where it kind of looks like CCP applies. So first of all, we have the Baker case. Baker walked around till he found a house to rob with his co-defendant. He then held the victims at gunpoint for 2.5 to 3 hours. They could have been planning during that time. They searched the entire house. They kidnapped one of the victims and made them go to an ATM. They went to a, quote, rural area. And that is not what we have. They couldn't get money or something at the ATM, and it ends up that the victim starts running and is chased. That is an example of code calculated and premeditated. That is clearly not what we have. The Wright case, which is WRIGHT, that's a carjacking. The defendant in that case said it cannot be code calculated and premeditated if he's under extreme duress. Then the court went on to some of the facts. There was an abduction in that case, and the victim was executed. 2 witnesses described what the defendant told them about the murder, how he lured the victim, and how he carjacked the victim. Distinguished shingle. The next two cases are all kidnapping cases. Calhoun. This one is interesting. The victim is bound, put in the trunk of her car, driven to the woods. The car is doused with an ignited fluid and left to die from smoke inhalation after a fire starts on the car. So that is showing an intent to kill, a heightened premeditation after a kidnapping in all one's acts. And finally, Thompson is also a kidnapping. The victims were driven to an isolated area, which we do not have. After the defendant walked into the office, I believe like a cemetery, with a gun and a knife. And after he walks in, he has them lay down on the ground, and the case continues on about the facts in that case. Those kind of seem like co-calculated premeditated. That is not what we have in this case, Your Honor, and we ask that you strike that as a matter of law, because you are the trier of fact and know the case law. Thank you, Judge.
All right. Mr. Terry.
Yes, Your Honor. So, Your Honor, I believe this is clearly a case of cold calculated and premeditated. We have an instance where we have an individual who says he was looking for her, clearly had a plan to find her. He then located her. He then drives her to this location, Judge. And I know Mr. Lemmer keeps wanting to say it's not isolated. This is the middle of the night. She leaves out that part of it. Okay, this is 3:30 in the morning, or 3 o'clock in the morning. He drives there. It's a dead-end street where he turns around, and he does turn the lights off as soon as he gets there. He also places his vehicle, Judge, and I think this is very important. Mr. Lemmer didn't mention it. He pulls the driver's side of the car up to that vacant lot. He didn't park in any other location around there. He didn't park in front of a residence. He didn't park on, like, right next to the corner. He parked right next to that vacant lot. Why would he do that, Judge? Because it's a spot where he could easily dump her body. This was an intended plan he had thought of and planned to do from the very beginning. He took her there. He obviously armed himself. Okay, that's one of the factors that's considered in this. He's a felon, so he had to find a way to get a firearm and got a firearm, armed himself, found her, drove her to that location, which obviously in the daytime it might be a different situation or a different scenario, but we're talking night. Even Mr. Creed said it was incredibly dark there, couldn't see anything. There were no street lights. He then pulls up there, asks her a single question. All we know is he said, "Are you having sex?" And she said no. And then he says, "Get out of the car." There's nothing else about any sort of an argument, anything like that, just that they were basically, he was upset with her for having sex. And we know from, I guess, Stanley Wilson that, at least if you believe him, that it was because of an STD. Either way, Judge, he then follows her out of that car. She gets out of that car, granted after being shot. He could have driven away. Again, there's case law about that where they could easily get away. There's no reason to continue on with this, but he did. He continued on, and he went and he executed her, Judge. And that is, execution-style killings are by definition cold. And that's in every single one of these cases I cite. So, Judge, I think this is very similar to all of these. Where a defendant has the opportunity to leave a crime scene with the victim alive, but instead commits the murders. Those are things that are found by their very nature. Execution-style killings satisfy the cold element of CCP. The calculated element applies in cases where the defendant arms himself in advance, kills execution-style, plans his action, and has time to coldly and calmly decide to kill. When he got out of that car, Judge, he had 9 seconds to decide what he was going to do, and he walked up to that young girl and shot her in the head. That is cold, calculated, and premeditated. Again, all of these cases I cite, they drive to remote locations or isolated areas. And again, it's the state's position that this does qualify. Granted, it's not an orange grove miles and miles away, but it is a dark, secluded area with in a vacant lot and a field, basically, where it's an easy place to leave a body. I was citing there Wright v. State, 1973, 277. Again, in Baker v. State, 71 Southern 3rd 802, execution-style killing is by its very nature a cold crime. Again, it says the calculated element applies in cases where the defendant arms himself in advance, kills execution-style, plans his actions, and has time to coldly and calmly decide to kill. A plan to kill may be demonstrated by the defendant's actions and the circumstances surrounding the murder, even when there's evidence that the final decision to kill was not made until shortly before the murder itself. That's another important aspect of this, Judge. There's no time limitation, okay? here it says, it may be demonstrated by the defendant's actions and the circumstances surrounding. It's the state's position, Judge, driving her to this location where she's not, as far as we know, she's unfamiliar. It's dark, it's a vacant alley or a vacant lot, and he pulls up there, the way he pulls up there, all of that shows a plan, a place to put her, and at least put her body after he kills her. And again, these cite other things, including the fact that they had ample opportunity to release the victim, but instead, after substantial reflected, acted out the plan he had conceived during the period in which the events occurred. And so, let's see. In Baker also, because the victim was shot in the forehead at close range, the physical evidence is thus consistent with an execution type killing, in case there's any question about whether or not this was execution style. Again, Calhoun v. State, 138 Southern 3rd 350. Manner in which defendant executed the crime is important. Where a defendant arms himself in advance, kills execution style, and has time to coldly and calmly decide to kill, the element of calculated is supported. Taking a victim to an isolated location or choosing an isolated location to carry out an attack can be indicative of a planned or prearranged design to kill. Exactly what the state is arguing in this case, Judge. Exactly what the facts seem to indicate. So that's why we cited that case, which was Calhoun v. State, 138 Southern 3rd 350. And then in 648 Thompson v. State, 648 Southern 2nd 692. Again, Thompson took the precaution of carrying a gun and a knife with him to the cemetery office. After he had obtained the check from SWAC, he drove the victims to an isolated area, forced them to lie on the ground. There's no indication of any resistance. Again, there's no indication that Nilexia Alexander resisted in any way. And again, advanced procurement of a weapon, lack of resistance or provocation, and the appearance of a killing carried out as a matter of course. Judge, I believe the state has proven all of that by the facts and circumstances surrounding the killing, the location where the killing took place, the execution style killing. Ms. Fawcett has provided me another case that I did not. It's called Squires v. State, 450 Southern 2nd 208, which states shooting victim 4 times in the head with revolver after initially wounding victim with a shotgun and firing the 4 shots at extremely close range indicates CCP. So Judge, based on all of that, the state believes we have established more than enough facts to prove beyond reasonable doubt to the this jury that this is a cold, calculated, and premeditated murder.
Rebuttal, Your Honor?
Yes.
Yeah, Mr. Terry is incorrect when he says there's no street lights. On that corner of Floribraska and Highlands, where the car is parked, I guess it's, I don't know if it's south or west, but short of the intersection, you can see the street lights on. So that is absolutely not true. He also misspoke when he said Mr. Creed never talked about an argument. Yes, he did. He said that when they talked about the sex, he got mad and there was an argument. So that was the testimony. Mr. Terry is using a comment about that was not in evidence, and that is, oh, Mr. Walker was a convicted felon. That did not come in, that is not evidence. All we know is he was looking for the girl. That's it. And that's after he was looking for a girl for Mr. Creed. I also take the fact that he parked the wrong way interesting, because not only is he shining his headlights into Mr. Wallace's home, not ending up in the dead end where he could have, but actually parking the wrong way on the street is indicative of being, hey, maybe someone will see this. Why is this car parked the wrong side of the road? He keeps saying, Mr. Terry keeps saying, executed, executed. We do not know anything about Miss Alexander's condition once she is either carried, taken out, walks out of that vehicle. So we don't know execution, we don't know if, we just don't know any facts. So the continuous use of the word execution. He made an interesting comment too. He said, as far as we know she was unfamiliar with the area, we gotta look at the evidence. And the evidence in this case does not support it. We were not provided the last case, but I can tell you that talked about a shotgun being used first, I believe, and then a firearm after that. So Your Honor, this does not rise to that level. Premeditated for the jury to have returned a first-degree murder, but does not classify for that heightened premeditation for this aggravator to apply, and we're asking you to strike it. Thank you, Judge.
I'm going to reserve on that momentarily as well, while I ask if there's any other issues we need to discuss. Any other issues we need to discuss?
Yes, unfortunately.
Okay. All right, let me get a time. timing on this? Because that jury's been back there for 45 minutes now almost. So how much longer?
So we have to talk about a situation and another motion I filed to exclude the testimony of Raymond Lee, and the prior violent felony. I think that's pretty much, is that the remaining issue? Do you have anything? Oh, and the victim impact judge, we were supplied with the victim impact late yesterday afternoon. I have taken a look at them. Overall, they're very good. There's only a few couple lines that, for the record, I want to object to. So that'll only take a couple of minutes.
Just overall, how much time do you think?
Those two issues, 15, 20?
For everything?
Oh, we also have a problem because if the court does not exclude Mr. Lee, but you will hear about this, we need to be able to depose him, but I have to explain to you why and what happened.
All right, court will be in recess for 5 minutes and we'll address those issues. And try to figure out what to do with the jury.
Court stands in recess.
Something. They're just doing a video, so I just quick update. Yep. Is there an adapter for this?
I'll give you one too. There's one down there. But I'll give you one.
I had to learn to adjust. It doesn't talk about the effect it had regarding her death. But the fact that it alludes to the fact that that no longer applies would show an effect on the community. So I think this letter's fine in its entirety.
Thank you, Judge. The next one, again, very minor, Nilexia Alexander, that is the grandmother of Nilexia. The court has already ruled about the New York trip, so for the record on her letter, Lexi always talked about going to New York. We were planning to surprise her with a trip for her 15th birthday. Sadly, we never had the chance. The court has already ruled that that is okay for Ms. Alexander. However, sadly, we never had a chance, does not go to the uniqueness of Ms. Alexander or the loss to the community. So based on the ruling, I'm still objecting to the line concerning the trip. However, I understand the court's ruling, but certainly sadly, we never had the chance. I am objecting to. So, Your Honor, and that's it for that one.
May I be heard, Your Honor?
Yes, absolutely.
I would cite to Jordan v. State 176, Southern 3rd, 920. It's a Florida Supreme Court case out of 2025. It indicates evidence concerning the impact of the victim's death on the family members is relevant for the impact. So this is the effect it had on the family.
It's another family member. I mean, it's analogous, but it's a different family member. So I'm going to allow that as well. Now, the question, what about the line, sadly, we never had the chance?
That's the impact it had on her family. This is the victim's grandmother.
I agree, and I agree with that as well. Just want to hear what you had to say. It's almost the same, but it's her, the effect on her. Okay.
And the principal, Delia Gadsden.
Delia.
Yarborough, is that right?
Delia Gadsden Yarborough.
Delia.
Yeah.
Judge, again, overall, this statement comports with the statute as well. I'm just consulting with co-counsel. Judge, I was looking at one of the paragraphs, but we don't have any objection to that letter.
All right, very good. Okay. Next on the agenda.
Okay.
And Ms. Fawcett, you may have these back. Thank you.
Thank you.
Okay. All right, we have a motion to exclude one of Mr. Terry's witnesses by the name of Raymond Lee. Raymond Lee was present during the prior violent felony incident in October of 2003. That's October 23rd of 2003.
Okay.
We are moving to exclude him, and if he's not excluded, we're gonna have to take his death oath for these reasons. Former Detective Drabenik and Mr. Lee were originally listed in this case as witnesses because I filed motions demanding to know, of course, what the PDF was and who the witnesses were and got the documentation appropriately from Mr. Terry. But then Detective Drabenik had changed to Detective Masucci. However, they didn't know where Mr. Lee was. And in fact, unfortunately, Mr. Terry only had Mr. Lee show up like about 2 weeks ago at jury selection. So he was nowhere to be found. I deposed Detective Masucci because he was going to be the only witness. There's a very long history behind this prior violent felony, and it can get very messy. We're talking hung juries, conviction that got reversed. This should be limited to the pleas that he entered in 2010. There's also a lot of issues with the identification. The appellate court ruling is very scathing on the weakness of the case and the ID that was done because Mr. Lee had done his own research with a potential hearsay name, found a picture, doesn't look at a photo pack till after he has a picture. It's a mess. So Mr. Terry specifically told me, and Ms. Dunker was there after we deposed Detective Masucci, I'm not using any witness. This is just too messy. I'm only going to use the certified judgment and sentence. And that was probably about 2 months ago, something like that, maybe a month and a half. And it remained that way until Tuesday night. Tuesday night, Mr. Terry did advise me, that Raymond Lee apparently showed up at jury selection. We had not been told that earlier, we were not told it until I believe it was Tuesday night, Mr. Terry can correct me. And until they called him as a witness. I said, well, you know, we have not, you said you were not calling me, you're using the certified, we have put that aside. Either way, we would have to do something to pose him or something if they're gonna call him. Then it's like, no, I'm not gonna call him then now, I'm gonna call Detective Masucci, who we've already deposed. I'm like, okay, now it's Masucci. But that's okay, Detective Masucci's not here, he's in Yellowstone. So then it became Detective Drabanek. And Detective Drabanek is here to testify, and we got a chance to speak with him, and I've got his report. I was specifically told last night, and I have the text, they are not calling Raymond Lee, that it is just gonna be Drabanek, which I don't have an issue with. Now this morning, I'm told they're using him. So Your Honor, we have not fully prepared then at this point for Raymond Lee. This became an issue to us Tuesday
Where is Raymond
night.
Lee right now?
He's here.
Okay. Well, we're gonna be taking a break for depositions this afternoon, so I can assume you'll get him done. And then,
That's-
The only,
yeah.
and that's fine, and I don't have a problem with that. Just if I can respond to a couple of points on that. And most of what Ms. Summer said is accurate as far as, you know, the
Okay.
conversations we had. However, my feelings have changed for a number of reasons. Number one, when I saw her motion basically trying to eliminate 2 of our aggravators, I realized that I may be stuck with just 1 aggravator, and all I've got is certified copies of conviction. So around that time, when I saw that motion, not knowing what your course.
I don't need to know your reason, it's okay.
Well, yeah, Judge, the fact of the matter is, we did not know or have contact with Raymond Lee until he showed up for the trial. And so at that point in time, he seemed to indicate to me he wanted to be a part of this. So I let Ms. Schlemmer know, and so that was kind of where we were gonna be with this. Then when I called him to tell him, hey, you need to come down for a depo, we need to get this, he's like, I changed my mind, I don't wanna be involved. At that point in time, I said, you have a couple of hours to think about it, but please, we need to know. He never called me back. I tried to reach him most of the day yesterday, he didn't call. That's when I sent the text to Ms. Schlemmer saying, he's not responding, we're not gonna call him. After I left work yesterday evening, Ms. Fawcett apparently was able to reach him, and he did agree to come down for Ms. Fawcett.
Okay,
I was told that this morning.
I
He's
understand.
here. The only problem with doing this deposition later is that we don't have that much to present in our case. Our case is very short. Literally, right now, it's gonna be Detective Drabanek, our certs.
well, you do them over lunchtime then, because we're not gonna bring these people in just to say, hey, thanks for coming back, see you in an hour and a half.
I understand, that's
So,
fine, Judge. We can.
I would do them over
We'll
lunch.
do what we can before, can we do the victim impact slightly out of order then, Judge? Well, we've already, you can kind of do the CCP.
Your order's your order, I'm not gonna complain.
Well, just based on the case law, we wanted to know if there was any objection.
Oh, I understand that, yeah, you gotta follow that part of it.
The case law suggests that the victim impact statement must be brought after a aggravator's been proven, but if they're not gonna,
CCP went through the facts.
the CCP is going through the facts, so I think we're okay on that. So,
Okay.
all right, that's fine, Judge. Yeah, we can- So I think there's enough we can do today before lunch, so we should be fine.
So Your Honor, I'm not taking away my objection, obviously, this is.
I understand that.
Phase, and
No, I
now
know
we're
that.
gonna be in crunch
I appreciate
time.
that.
So thank you. Did you wanna address really quickly the photographs that they have for victim impact? And there's also photographs.
That just came in this morning, right?
Yes.
You might as well take care of that.
Yeah, might as well. Ms. Fawcett, do you guys have a chance to show this to the judge?
Yes.
We have photographs of Nilexia Alexander and photographs of Elaine Caldwell.
Okay,
Would you like me to approach her?
yeah, let me look at it.
This is the section for first victim, second.
And you plan on introducing both packets, correct?
Yes, Your Honor.
Victims is the first victim. make this a feature. And then this packet, this would be our current victim. How many do you say? All right, okay, regarding the victim in the first case, what is your opinion on those?
Yes, Judge, we are objecting to those. As we all know, the Florida Supreme Court is quite clear that we cannot make the prior violent felony the feature of the case. We are already calling the lead detective. We are already potentially calling Raymond Lee. The Duncan case that I sent to the court, in that case, they talk about like gruesome photos, but they're talking about the use of photos and how they already have the detective. We're making it the feature of the case with autopsy photos. We're not actually getting, as far as I know, she was shot one time. I don't think any medical examiner is being presented to say it would assist or aid them in any way. So based on Duncan, and the fact that it makes it more the feature of the case, and we already have testimony, we are objecting to any photographs of Elaine Caldwell. If in fact the court was going to allow a photo, which I would still object to, we certainly are objecting to the autopsy photos. There is one of her, if the court, but I'm not giving away my objection, just saying if the court wants to consider that.
State, just response to the first crime victim.
So, Your Honor, the state would cite to Wyatt v. State. It's found at 641 Southern 2nd 355. It's a Florida Supreme Court case from 1994. So the Florida Supreme Court has previously indicated that photos of the other victim may be admissible. So this is another victim. We're trying to show the injury to this particular victim. The lead detective is present to testify, and he also attended the autopsy. Why is this relevant? Because this is another female victim who was shot in the head, and the victim in this case, Nilexia Alexander, was shot in the head. It is not that the court is indicating that the prior victim's photographs are inadmissible. It's to the contrary. The Florida Supreme Court indicates that it is appropriate for the jury to see photographs of the prior victim. The Duncan case that the state has cited does not stand for the notion that that photographs of the prior victim are inadmissible. In fact, in the case cited by the defense, it says the defendant murdered his fiancée with a kitchen knife, and they talked about that. The defendant in that case argued that the trial court committed reversible error in admitting extremely gruesome photos that were depicting gaping wounds to the prior victim's head and face. The photographs related to the defendant's 1969 conviction of second-degree murder. Although the Supreme Court did agree that the prejudicial effect of the gruesome photographs outweighed its probative value, the error was harmless beyond a reasonable doubt. Once admitted, no further references were made to the photographs. Moreover, the jury was well aware of the fact that the defendant had previously been convicted of a brutal attack. We are establishing that the defendant was in fact convicted of a brutal murder, that in fact the murder was a shooting, that in fact this is that prior victim. The photographs that have been provided to the court depict that particular injury. The detective went to the autopsy.
I understand.
And I just selected very few photographs that were not overly gruesome in any way.
Judge, I cited Duncan v. State just for the record. The court has it, so does the state 619, 7nd 279. Of course, we know it's within the court's discretion. There's no bright line rule that photographs admissible, sure, but it's also an issue of 9403, as Ms. Fawcetti had mentioned, that the this is gonna become the feature of this case. I mean, we're calling already Raymond Lee, we're calling Detective Drabanek. It's, the probative value is outweighed by the prejudice, and it's gonna make this the feature of the case, and the Florida Supreme Court is clear, that that cannot occur.
The state has to be able to prove its aggravating
Here's
factors,
one.
and one of the aggravating factors in this case is the prior violent felony, which is this and.
I understand what you need to prove, stand by. Put this one and this one. All right.
And one more comment on this, Judge, the aggravator is the conviction. The conviction was a plea to this case. That is another factor why we don't need to be going into.
It's
all
clear, though, the
aspects.
pictures are allowed. I understand your argument and your objection. So regarding the first victim, I've chosen 2 photos that I'm going to allow. And I will give them back to the state. It's going to be, you guys want to approach.
Oh, yes. preliminary instructions, I believe they are standard. I didn't make any changes that do apply in this case, which is gonna be your instructions from 2018.
Correct. Any disagreement?
Judge, the instructions, I thought I might provide standard instructions as well.
Well, you guys have each have given me some. If you want to go over that during the lunch break and see if there's any,
But you're gonna read them now?
You're gonna
though.
read it,
oh, you want to go through them right now? Oh, you want to do the charge conference now?
No.
Oh, yeah, you're talking about just the preliminary instructions.
Yes.
Yeah, let me look, because there's two different sets.
The state took it directly from the statute book, which I believe is.
The 2018 statute book,
Is that?
the old statute book, right?
I'm not sure, I probably took it from the English statute. I
So I
didn't.
have a copy.
Let me find,
I do have a copy, and I can show it to Mr. Thierry, preliminary
Come help me
instructions
sort
from
through
2018.
this.
It's from 2018.
Let's try to find that.
I got him out of the way.
No, I recognize it, I thought it was fancy. Okay, I didn't understand. Judge, I have no objection to the defense's preliminary instructions, I didn't realize that the ones I was getting was from today's, they changed quite significantly.
Yeah, they have quite a-
Yes.
So I didn't realize I was putting today's, and this should be, she is correct, it should have, 2022's, I believe, should be allowed.
You just show 'em it's 3 pages, correct?
Yes.
Just want to make sure.
And Judge, if you can just kind of let the jury know that the delay is no fault of the state or the defense.
Oh, I will.
Okay, don't want them
Blame it
to
all on me.
be mad at us.
Do you not have the copy I sent?
I have them.
Okay.
What I'm saying is logistically, you bring them in, you want me to read these and then dismiss them for lunch? Or you just want to dismiss them for lunch and you start at the top?
And we can probably get openings in, I would leave. My opening's not
Okay.
super long. I don't think either of our
We'll
openings.
do that. So preliminary instructions, openings, lunch break. Very
Okay.
good.
Got it. Thank you, Judge.
What time?
Are you gonna tell them it's gonna be a short day today?
I will. I'll let them know it's a short date and that the delays have been my need for information and the attorneys are not to blame. I'll also ask them.
All rise for the jurors.
Y'all may be seated. Thank you, ladies and gentlemen. All right, first off, were you all able to follow the court's instructions? No issues? Nobody had any contact with any media stories, print, radio, TV, YouTube, none of that? And no one spoke to you about the case, and you never spoke to anyone about this case? All right, very good. Also, a couple of things just logistically. We're going to be breaking around 2 o'clock this afternoon, so you'll have an early day today. The state and the defense don't anticipate that this is going to be a lengthy process overall. So that's so we can do some extra work in the afternoon. The attorneys are still going to be working hard. And also, the delay today was because of me. I had them in here at 8:30 this morning, and we have been working right up until the very second we went and got you. So if you want to be mad at someone, it's all on me, because they have to listen to what I say, apparently. And after that, I think we're ready to go. So, ladies and gentlemen, members of the jury, you have found the defendant guilty of 1 count of murder in the 1st degree. This punishment for this crime is either life imprisonment without the possibility of parole or death. Before proceeding further, it will be helpful if you understand how the proceedings will be conducted. The attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the penalty phase of this trial. What the lawyers say during opening statements is not evidence, and you are not to consider it as such. After the attorneys have given their opportunity to present their opening statements, the state and the defense may present evidence relative to the nature of the crime and the defendant's character, background, or life. You are instructed that this evidence, along with the evidence you have heard during the guilt phase of the trial, is presented in order for you to determine, as you will be instructed, 1, whether each aggravating factor is proved beyond a reasonable doubt, 2, whether the aggravating factors found to exist beyond a reasonable doubt are sufficient to justify the imposition of the death penalty, and 3, whether mitigating circumstances are proven by greater weight of the evidence, 4, whether the aggravating factors outweigh the mitigating circumstances, and 5, whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. At the conclusion of the evidence, and after argument of counsel, you'll be instructed on the law that guides your deliberations. Aggravating factors. An aggravating factor is a standard to guide the jury in making the choice between the verdict of life imprisonment without the possibility of parole or death. It is a statutorily enumerated circumstance that increases the gravity of the crime or the harm to the victim. You must unanimously agree that each aggravating factor was proven beyond a reasonable doubt before it may be considered by you in arriving at your final verdict. In order to consider the death penalty as a possible penalty, you must unanimously determine that at least one aggravating factor has been proven beyond a reasonable doubt. The state has the burden to prove each aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proved beyond a reasonable doubt, and you must not consider it in proving your verdict as to the appropriate sentence to the court. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, conflicts in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, you should find that the aggravating factor does exist. Before moving on to mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, let me start that. Before moving on to mitigating circumstances, you must determine that the aggravating factors are sufficient to impose a sentence of death. If you do not unanimously agree that the aggravating factors are sufficient to impose death, you do not move on to consider the mitigating circumstances. Mitigating circumstances. Should you find sufficient aggravating factors do exist to justify the imposition of the death penalty, It will then be your duty to decide whether the aggravating factors that you unanimously find to be proven beyond a reasonable doubt outweigh the mitigating circumstances that have been established. Unlike aggravating factors, you do not need to unanimously agree that a mitigating circumstance has been established. Rather, whether a mitigating circumstance has been established is an individual judgment by each juror. A mitigating circumstance is not limited to the facts surrounding the crime. It can be anything which might indicate that the death penalty is not appropriate for the defendant. In other words, a mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that reasonably may indicate that the death penalty is not an appropriate sentence in this case. A mitigating circumstance need not be proven beyond a reasonable doubt by the defendant. A mitigating circumstance need only be proven by the greater weight of the evidence, which means evidence more likely than not tends to prove the existence of the mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you may consider it established and give that evidence such weight as you determine it should receive in reaching your conclusion as to the sentence to be imposed. Once the state has presented evidence of an existing aggravating factors, victim impact evidence may be presented. Such evidence is only presented to demonstrate Nilexia Alexander's uniqueness as an individual and a loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. In every criminal proceeding, a defendant has the absolute right to remain silent. From the exercise of the defendant's right to remain silent, a jury is not permitted to draw any inference regarding the existence of an aggravating factor or an appropriate sentence. And the fact that a defendant did not take the witness stand must not influence your sentencing decision in any manner whatsoever. State, you may proceed.
Thank you, Your Honor. Ladies and gentlemen, Nilexia Alexander is not the first person Ronny Walker has killed. See, back in October of 2003, a woman by the name of Elaine Caldwell was shot in the head. Her home was broken into, a robbery was taking place, and ultimately, that man seated right there, Ronny Walker, was convicted of her murder. That, ladies and gentlemen, is an aggravator, and one of the two the state will prove beyond a reasonable doubt, and which makes Ronny Walker death eligible. We are now at the stage where guilt is not an issue. You have already found the defendant guilty of the crimes he was charged with, and so now we are at the stage which is called the penalty phase. The issue now is your determination of whether the sentence should be life in prison without parole or death. The state will be presenting two aggravating factors. One of the aggravating factors, and I'm going to get into in a minute, that you've already really kind of heard of and heard through the evidence, because here you can still consider all the evidence that was presented in the case, in the guilt phase, okay? So one of the aggravating factors is an aggravating factor called cold, calculated, and premeditated. And you're going to learn what exactly that is and what the state has to prove. The other aggravating factor that the state has claimed in this case is a prior violent felony conviction. And that is the death of Elaine Caldwell at that man's hands. Now, although you probably don't need any reminding of the process that both Ms. Fawcett and Ms. Schlemmer covered so thoroughly during the voir dire, the state must prove at least one of those aggravating factors beyond a reasonable doubt before you can even consider death. And I think you've heard that even in the judge's preliminary instruction there. And we have no doubt that you will find both aggravating factors have been proven beyond a reasonable doubt, but you need at least one of those aggravating factors proven beyond a reasonable doubt by the state before you can then consider death. And again, everything that was presented and argued in the guilt phase can be considered by you when considering certain aggravating factors. And in this case, that is the cold, calculated, and premeditated. So the state is not going to come and have to represent all of those witnesses and all of that evidence. I think you all would go crazy. No, you can consider all of that. It is considered part of this trial as well. So let me talk to you a little bit about cold, calculated, and premeditated. And obviously this is a aggravator where there is a heightened premeditation in it's calculated and it's done in a very cold manner. So in this particular case, you heard evidence from Robert Quincy Creed that he was searching for her. Clearly had a plan in mind.
Judge, may I read?
Yes.
And again, we're not going to represent all this. I'm just showing or explaining to you some of the things that you heard that may apply. But the fact that he was searching for her, that he got her in the car, bought her a drink, and took her, most importantly, to this location in the middle of the night, a dark location, according to Quincy Creed, a location where he pulled up so that the car was easily accessible on the driver's side to that vacant lot where her body could be left. All shows, ladies and gentlemen, heightened premeditation. And all of that is evidence you already have, and evidence that you can consider when determining whether or not it was cold, calculated, and premeditated. And then you heard from Quincy Creed she was shot in the car, and as I described to you earlier, the evidence we believe showed that she walked out of that car and that Ronny Walker confronted her in that vacant lot and shot her 3 times in the head. That is basically an execution style killing.
Objection, Your Honor, improper argument. And same arguments made at the bench.
All right, I'll sustain.
So you can consider how she was shot in determining whether or not this was a cold, calculated, and premeditated kind of case. All of that the state believes, will add up to cold, calculated, and premeditated. That is one of the aggravators, and again, you're not going to hear a bunch of evidence. That's why this is going to be a much shorter presentation for you all. We're not going to go back through all that. We're going to rely on your memories of all of that and informing a decision as to whether or not that aggravator applies. The second aggravator, however, is one you have not heard or learned about until today. So we do intend to present some evidence. It's still going to be very short and it's not going to be as significant. We're not going to relitigate that case. We're not going to do all that, but we are going to present a couple of witnesses, or at least one witness, to tell you sort of what happened there. Give you a little bit of the facts surrounding what occurred so you can kind of understand about the prior violent felony. And you're going to hear about Elaine Caldwell, and you're going to hear how this was her home that she was in when Ronny Walker came in there. You're going to hear about the fact that this was a robbery. And that because of them breaking into the home, it was a burglary. That there was another accomplice with that individual. You're going to hear that she was shot in her bedroom and shot in the head and killed. You will see certified copies of convictions that indicate Ronny Walker was convicted of those crimes. You'll hear from the lead detective at the beginning of the investigation, who will describe to you the scene. And he will also tell you he attended the autopsy and describe to you the injury that Elaine Caldwell suffered. All of that will be brought to you. Again, in a more truncated fashion, but a way for you to understand what happened in that prior violent felony conviction. Those 2 aggravating factors will be proven to you beyond a reasonable doubt. And at that point in time, you can consider whether to sentence Ronny Walker to death or life in prison. You will then decide whether each aggravating factor can sustain a sentence of death. And I submit that you will most likely hear mitigation for Ronny Walker. And you will need to consider all the mitigation the defense provides and give it whatever weight you feel it's appropriate. Then you will weigh the aggravating factors that the state believes it will prove to you beyond a reasonable doubt against those mitigating circumstances that you will hear about. And again, you give each the weight you feel they deserve. And then if you find that the aggravating factors outweigh those mitigating circumstances, and again, this must be unanimous at this point, then you go to the ultimate decision, and that is whether or not the defendant should be sentenced to death. We are confident, ladies and gentlemen, that we will have proven our aggravating factors, that you will give them great weight, because they deserve great weight, and that you will find these aggravating factors outweigh the mitigating circumstances you're going to hear, and that the appropriate sentence in this case is the sentence of death. Thank you.
Schlemmer, when you're ready.
Thank you, Judge. May it please the court, counsels. Good morning. My name, you haven't heard much about me since jury selection. My name is Carolyn Schlemmer again. I talked with you all quite a bit about your feelings about the death penalty. Ladies and gentlemen of the jury, we want to thank you. We want to thank you for the service you have done in this case. It has been over 2 weeks that you have been with us. The time and attention you have given to all of us, including Mr. Walker. We want you to know that we fully accept your verdict. Fully accept your verdict. With your verdict, you have assured that Ronny Walker is punished. You have assured with your verdict that he will die in Florida State Prison. He will never be released, and he will be punished. You have assured that. The decision you now have to make is, at whose hands does he die in Florida State Prison for what he did to Nilexia Alexander? Because life without the possibility of parole, as you remember from jury selection and Mr. Terry talking with you, life without the possibility of parole or the death penalty are the only choices. And you are assured that Mr. Walker will never walk free. No matter what, Mr. Ronny Walker will die between the cement walls of Florida State Prison. Now, this is our opportunity, and I want to make it clear as well. We are not trying to excuse what was done to Nilexia Alexander. You will hear from Nilexia Alexander's mother and her grandmother. We anticipate Mr. Terry will present them. Ashley Alexander is a wonderful woman. You will hear that's a good family. So we are not in any way, shape, or form going to present mitigating circumstances to you to try to excuse Mr. Walker's behavior. But we have to give you that information, and the law recognizes that information, mitigating circumstances. Not an excuse. Maybe an explanation, maybe explaining, and being given to you so you can make that crucial decision, that individual moral decision we talked about during jury selection. And I agree with Mr. Terry when he summarized the law. There's many steps you will need to go through when it is time to go back and deliberate Mr. Walker's fate of how and at whose hands he will die. You have to find an aggravator unanimously beyond a reasonable doubt. That makes him then eligible, exactly as Mr. Terry indicated. You then have to find that those aggravating factors are sufficient for the death penalty. You then look at mitigating circumstances. You then look at whether the aggravating factors outweigh the mitigating circumstances. And as Mr. Terry said, once you have gone through all of those steps, you're going to make that crucial decision. And you'll hear more later on. The judge will be giving you more about the law before you go to deliberate. Remember, just keep in mind, as we talked about during jury selection, that even if you find that final step, that those aggravating factors outweigh the mitigating circumstances, you can still, no matter what, go life without the possibility of parole. And that is what we are going to be asking you to do. I want to tell you a little bit about Ronny Walker. Ronny's not perfect, certainly. You've heard the case. No one is standing up here saying that. But you've got to make a critical decision now. But some of the things you will hear, we want to tell you about. January 22nd, 1978, Ronny Walker was born. At the time of Nilexia Alexander's death, he was 44 years of age. He is now at the age of 47 in his life. Ronny has 5 siblings. He's one of 5, one of 6. He has cousins. He has his mother. You will hear of some happy times that Ronny had in a close-knit family. But Ronny Walker is a product of his environment. You will hear from his mother, Emma Hamilton. Emma will talk to you about Ronny's life as a child. You will hear that she raised Ronny and his siblings as a single parent. She'll talk to you about that. Up until about the age of 10. Ronny was with his siblings until about that time. You will also hear that because Miss Hamilton is a single parent, his father was never in the picture. In fact, Ronny doesn't know his father. He was never a part of Ronny's life. His name is Larry Walker. He took off on Emma and left her with the 6 children, 3 girls and 3 boys, one of which is Ronny. She will tell you Ronny was quite sick as a child. Ronny suffers from seizures. Seizures that Miss Hamilton will describe to you that happen, and sometimes multiple seizures in a day. He had been hospitalized at 6 months of age for double pneumonia and bronchitis. And after that point, so about 6 months of age, the seizures started and continue to this day. But these seizures would result in head injuries. And Ms. Hamilton will explain to you a seizure even caused him to fall out a window and drop 2 stories and hit his head. You heard in the jail calls that you heard during the guilt phase, you might have heard a stutter. She will talk to you, and other family members will, about his speech being delayed and the stuttering that he speaks at certain times. Now, we're about at 10 years of age. Ronny's growing up with his siblings. But at 10 years of age, Emma Hamilton will tell you she lost custody, gave up custody of her children to her sister, who is now deceased, Gloria Hamilton. And the children were sent in all different directions. The family was broken up. Ronny is 10. Ronny and his brothers, John and Antoine, nobody knows today where John is, and Antoine is now in prison. Ronny and his brothers stayed with his mom, stayed with Gloria, and were raised by Gloria. His sister Paulette was sent off to live with her father, and his sister Tangi was sent to live with her father. So at 10 years of age, his family was separated and torn apart. So we have no father, and now we have no siblings. You will hear that Gloria moved frequently. Ronny changed schools frequently because of that. He never graduated high school, never got a GED. You will hear Gloria did not live in safe neighborhoods. All the neighborhoods she lived in had drug dealing and violence. Emma Hamilton, after she lost Ronny and all of his siblings to Gloria and the custody of her, Emma then spiraled into drugs and alcohol. And Emma will be honest and tell you that she has an addiction that started about that time, and she is as well. She is mentally ill. Gloria moved around a lot. Ronny had to change schools, and when Gloria moved around with the children she did have, including Ronny, it was not moving to good areas. It was a bad area to another bad area. School issues started for Ronny. Emma will tell you about the 10 years of age. The seizures will continue. You will hear that. Now, you will also hear that Ronny eventually had 3 children of his own. Ronell, his son, Ron J., a son, and a daughter named Paris. In 2021, Ronell, this is about approximately a year before the tragic death of Nilexia Alexander, that Ronell was murdered, wounded by gunfire, and was killed. You will hear how that affected Ronny. About that same time in 2021, Ronny's grandmother, her name is also Emma Hamilton, Emma's mom, also died, right about 2021. I don't think Emma's going to be able to give you an exact date, but it's right about a year before the tragic death of Nilexia. You will hear how they were close. You will hear as well from one of his reunited sisters. And she'll tell you a little bit about how she doesn't even know what her real name is, but her name is Tangi, or Tanya Hamilton. Now, she was sent at about the age of 10, when Ronny went with Gloria and his brothers. She was sent to be with her father, while Paulette, as I said, went to her father. But Tangi never was able to have a relationship with Ronny. In fact, she had to use Ancestry.com and Ancestry sites to be able to get her family back. She will tell you that Ronny and her were respectfully about 3 and 4 years of age at the time. They never grew up together, and now they've been able to reconnect, though. And she will tell you that she loves and supports Ronny. Ronny's cousin will speak with you. His name is Davis George Jr. And he's going to talk to you about the fact of the conditions living with Gloria and the bad neighborhoods and the violence. Ronny wanted to always be at his house, Davis's house, who was close to Ronny growing up. He was close to his family members growing up. He will tell you how Ronny basically lived on the wrong side of the tracks after being taken from his mother and given to Gloria, where Davis is on the other side of the tracks. A good house, lots of sports, his children are successful, and he has had a productive life. And he'll talk to you about the difference and how Mr. Walker always wanted to be over at his house when he was young. And he supports Mr. Walker. And you'll hear from other family members about the effect of Ronny never knowing his father, the death of his son, and the death of his grandmother about a year before this. The witnessing of seizures, the family background. We're going to talk a little bit. We're going to have Emma paint the picture for you who everybody is, because you're going to hear some names, and how they support Ronny. Please, please remember as you're listening to this evidence, again, none of this is presented as an excuse at all. It is to help you in making that crucial decision you are about to make. Mr. Terry indicated you've already heard facts about cold, calculated, and premeditated. However, that requires a heightened premeditation, and Mr. Terry acknowledges that. You have found him guilty of premeditated first-degree murder. However, this aggravator is a heightened premeditated, over and above your finding of premeditation. There has to be a careful plan, pre-arranged, and there must be time for substantial reflection. So it is different. Part of the instruction you will hear later is, of course, the definition of premeditation, as you have found Ronny guilty, but it will talk to you about how it is much above that. And I will submit to you at the end of this, the facts do not indicate a careful plan. The video that you saw showing the vehicle, that's a residential neighborhood There's street lights. Ronnie's got his street lights on. Before that, he picks up Nilexia with Robert Creed. The lights are on. It was very bright. You can look at that video again if you'd like. But he goes down Floribraska and makes a U-turn because it's a dead end, comes back up from the dead end and parks at the vacant lot. And it's approximately 47 seconds in the vehicle at the time Nilexia is killed. And the events before the car pulls away. The car only shuts off its headlights when it's parked. There's a little, when it starts to go from that lot, puts lights back on, they flicker off, then they come back on. This is a residential area. There is no evidence that you have heard at all in the first stage that he had some plan to kill her with that heightened premeditation. Certainly the premeditation you all found, and with the number of gunshots. But this is different. This is much more heightened. There was no evidence that he wanted to kill her, intended to kill her, planned it, and had a prearranged, careful design. Robert Creed said the only thing, they go out, Ronnie's trying to find a girl for Robert Creed, and then Robert Creed says he was, quote, looking for the girl. That's it. He picks her up. They go to this residential area, which Detective Whelan himself described as a residential area. So we submit to you that when you have, and you've heard all the evidence, you're pretty much not going to hear any more evidence about that, as Mr. Terry said. But when you get the jury instruction and you see the difference from your verdict already, we submit to you that they clearly will not have proven cold, calculated, and premeditated. A prearranged, heightened premeditation with a careful plan to murder. There's no evidence of that. That is an aggravator in the state of Florida. The state is seeking it. It is up to you to make that determination, and I submit it is what you have heard clearly does not rise to that level. And you'll hear the instruction the judge will give you, and we'll talk more about that later. You can also consider things from the guilt phase. His cooperation with law enforcement, his consent for a buckle, the fact he talked to them. Those are things also that you can consider. And then, of course, any mitigating circumstances presented or anything presented during the guilt phase by the state of Florida. One thing I want to tell you about his conviction. The incident occurred on October 23rd of 2003. Detective Drabenik was the original officer, original detective. Mr. Terry indicated he is in fact calling Detective Drabenik. Almost 6 years later, Detective Drabenik will tell you the case went cold. But in 2010, and so the case itself, you're going to see two different judgment and sentences that Mr. Terry is going to put into evidence. They are from the same incident, so we just want to make sure that you know that, from an incident occurring on October 23rd of 2003. But what you're going to hear, Ronny Walker pled to those charges. He pled. Please, none of this, as I said again, that we will present to you is going to be an excuse. We are empowering you for your individual moral decision. In making that decision, you will make sometime in the next few days. And remember mercy. And because the aggravating factors you can believe outweigh the mitigating circumstances, you can still give mercy. These are not shown as an excuse, but to show you that man is broken. And he is worthy of a life sentence without the possibility of parole, and not the death penalty. You will not hear that this is one of the most aggravated and least mitigated cases. He's broken. He will die in Florida State Prison, and he will never get out. And that's what we are going to be asking you to do after all of the evidence and you hear the law. Select life without parole. And on behalf of everybody, I thank you. Thank you, Judge.
All right, ladies and gentlemen, we're going to go ahead and take our lunch break now, and then we come back. Party will begin presenting their cases. So I remind you not to talk to anyone. about the case or listen to anyone who is about the case, remember there's people all over. Make sure you stay away. Thank you. See you
All
at
rise.
1:15, excuse me, 1:45. Is that right? No, 1:15, never mind. Never was good at math. Jury's left, y'all may be seated. Any matters we need to discuss before we recess?
Judge, just for the court's, knowledge, like, we're having a hard time getting a court reporter
No, there's one in there.
for the death. You have,
There's a court reporter in there. I just got a message from.
okay, cool, thank you.
Thomas Hall, one of the easier ones.
Justice walked dusty roads, traveler by and by, with calloused hands and weary eyes beneath the open sky. He'd stop and rest where stories grew in whispers long and tall.
They're allowed to present evidence. I believe that the evidence that they have presented and what I have limited them from actually being able to show falls within all those Supreme Court rulings. And I'll deny the same ruling on your objections, for the record. All right, anything else?
Yeah, I'm just gonna make sure, and I understand, like, when we talk about jury selection, I'm going to make sure I make the objection before it.
Absolutely.
Just to,
Understand.
because of the nature.
Got to preserve the record. I understand that, so we're good. Anything else? All right.
Traffic knows too, right? Like, not to talk about.
I'm only talking to him about seeing the outfit.
Perfect.
It's been a while. Welcome back.
What number did
It's
you?
4. He said 4.
He said 4,
He said 4. What do you got?
I actually have. I could count it. At least 3 there. So we had 1, 2, 3, 4, 5. I had 6.
I'm not gonna let you know.
Let me see the number.
He's not the first witness. Is your witness out there the one I need to?
No, he wasn't out.
Told him 1:15, so.
If he's there, and then I can just do this, so we don't have to delay.
He wasn't out there, Judge, when TJ checked. He wasn't out there when TJ just checked.
Okay.
There. But I will ask him.
All right, we're good.
Should release him. Just in case.
All rise for the jurors.
Jury's back, y'all may be seated. Welcome back, ladies and gentlemen. Once again, no issues with the court instructions, no one approached you talking about the case, you didn't see any media, didn't talk about it amongst yourself. Perfect, very good. Mr. Chair, whenever you're ready.
Yes, Your Honor. Judge, at this point in time, prior to calling our first witness, the state would move into evidence for this portion of the proceeding, State's Exhibit 2A and State's Exhibit 2B.
Any objection?
No objection, Judge.
States 2A and 2B are admitted into evidence.
Judge, and if I may publish these to the jury.
Yes, sir.
And these are the certified copies of convictions. And this is 2A, which is the certified copy of conviction for case number 09-CF-015021. And I'm now going to publish 2B, certified copy of conviction for case 10-CF-006452.
May we approach?
Yes. Ladies and gentlemen, just a reminder that those two certified copies of convictions are from the same event. It's the same charge incident.
Judge, this time we say we call Dennis Drabanak.
Good afternoon. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir.
Good afternoon. Are you ready, Mr. Chair?
Thank you. Good afternoon, sir. If you can tell the jury your name and spell your last name for the court reporter.
Name's Dennis Drabanak, D-R-A-B-I-N-I-A-K.
All right. And, sir, how are you currently employed?
I'm retired.
Okay. When did you retire?
I retired from TPD and Tampa Police in 2010.
All right. After working with Tampa Police, did you work anywhere else after that?
Yes, sir.
Where did you work after that?
State Attorney's Office for, till last year,
All right.
14 years.
And you were an investigator at the state attorney's office?
Yes, sir.
All right. Now, back, you said you retired from TPD. What year was that?
2010.
Okay. Prior to retiring at Tampa Police Department, what positions did you hold at that department?
I was a detective for most of my career. Narcotics first as a young man, then homicide, and a trip around patrol, and then back at homicide and robbery, and then intel at the end.
All right. Now, back in October of 2003, what position did you hold at the Tampa Police Department?
In 2003, I went back to homicide.
Okay. And were you involved in the initial investigation into the death of of Elaine Caldwell?
Yes,
And what position did you hold in the investigation?
I was a lead detective at that time.
All right. Did you respond out to the scene?
Yes, I did.
Okay. Describe for the jury, if you can, the scene when you arrived at the location.
It was pretty chaotic. Quite a few people there. The street was full of people. It was at the 2013 Eskimo, Hillsborough County, Florida. And so I got there, I met with another detective, and was briefed by the on-scene supervisors and the adverse detectives, and then initiated our investigation.
All right. What was this location?
It was a 2013 Eskimo.
What was it? Was it a home?
It was a house, it was a residence, excuse me.
It was a residence? Okay. And was there a crime scene tape out when you arrived?
Yes, there were.
All right. And was the scene actually inside the residence?
Yes, it was.
Did you go into the residence?
Yes, I did.
What did you observe when you went into the residence?
Well, when I went to the residence, I met with one of the people there that was Raymond Lee. Met with him. I met with a little girl, and then spoke to him for a minute, and then he showed me where the decedent, Elaine Caldwell, was.
Did he give you information as to what took place or what had just happened?
Objection, hearsay.
I'm not asking him what information.
Oh, objection.
Did he give you information about what had happened?
Yes,
And did you speak with the young girl that was there as well?
yes,
Was she able to also give you some information about what happened?
yes.
Okay. And where was the victim, Elaine Caldwell, was she still at the scene?
Yes,
Where was she?
in the master bedroom.
All right. And did you go in and find her or see her?
Yes.
And what was her position? How was she positioned?
She was at the foot of the bed, between the end of the bed and a dresser. It was a narrow area, and she was slumped down on her knees. Part of her body was on the mattress, the foot of the bed.
All right. So at that point in time, you kind of took over or were the lead in the investigation, correct?
Yes, yes, sir.
And you said you obtained the statements from the witnesses who were present at the time?
Yes, sir.
All right. And after all of that, did you later attend an autopsy in this case?
Yes, I did.
And that was the autopsy of Elaine Caldwell?
Yes, it was.
I'm going to show you what's been marked as States 5A1 through A3. You can take a look at that. Look at those pictures, please. Do you recognize those?
Yes, sir.
And what are they?
They're photographs of Elaine Caldwell.
And do these pictures fairly and accurately represent what they are showing in these pictures?
Yes, sir.
Judge moved out States Exhibits 5A1 and through A3 admitted into evidence.
Defense?
Same objection.
Same rulings, then they may be published.
All right, thank you. In States 5A1, what are we looking at here?
We are looking at the DL driver's license photo of Elaine Caldwell.
All right, and this was the individual you found dead in that residence when you arrived there that day, is that right?
Yes, sir.
All right. In States Exhibit 5A3, what are we looking at here?
Photograph of Elaine Caldwell at the medical examiner's office.
And you in fact went there and you were present while the autopsy was conducted in this
Yes.
case, correct? And what injury did she have?
She had a gunshot wound to the head.
All right. Showing you what is marked as 5A2. Was this in fact the bullet wound that you observed that day to the head of Elaine Caldwell?
Yes, sir.
All right. Now, Detective, did you ever finish with this case or solve this case?
No.
Okay, so there was a certain point in this investigation where you moved to a different unit or different area?
Yes, sir.
All right, but you were the initial lead and you were the one who responded to the scene as well as to the autopsy, correct?
That's correct.
All right, I may have a moment, Your Honor?
Yes.
Nothing further this witness.
Good afternoon.
Good afternoon.
Just one or two questions for you. So when did you leave the unit, or when did you retire?
I retired from the city in September of 2010. excuse me, I left the unit, I believe, in '04.
Okay.
I went to,
This incident with Ms. Caldwell occurred in 2003?
yes, ma'am,
Okay. And then you left the unit in 2004
that's correct.
and officially retired in 2010?
Yes, ma'am.
All right. And when you left the unit, the case went cold, correct?
Yes.
Yes. Okay. May I have a moment?
Yes, ma'am.
No other questions? Thank you.
Can you redirect?
No,
You're just gonna speak, excuse?
yes, you may.
Free to go, thank you.
Thanks, sir.
Statement, call your next witness.
Did we vote?
Yes, come on up. All right, ladies and gentlemen, we're gonna take about a 2-minute recess, so if you'll just keep them close, we're gonna bring them right back.
All rise for the jurors.
Teresa, left the room, you all may be seated. Go ahead and bring them in. Just one of them stops out and stays in this car. We're just gonna swear you in, I have to ask you a couple of questions.
You can raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, sir.
You've had a chance to talk to the attorneys about what you can and can't say, correct?
Correct.
This could be real important that you stay inside what they told you not to say. Because if you get emotional and you say things that you may wanna say, that you're not supposed to inside of the courtroom, then this whole thing's gonna have to start over from the very beginning. And we don't wanna go down that road, right? So
Correct.
just make sure that whatever those attorneys told you about what you can say, go ahead and say that, and stay away from anything they told you not to bring up. Okay, I really want you to do that for the court, all right?
Okay.
I appreciate that. You can go ahead and have a seat, sir. Thank you for coming down here.
I'm just gonna put it on the record so that it's clear.
Okay? And she's just gonna repeat it so it's in the record,
Yeah.
what we can and can't say.
Good afternoon, sir.
Good afternoon.
Okay. Well, I know that one of the ways that you knew, or that you found out the person that was in your home was that you looked at the Florida Department of Corrections website. Is that correct?
Yes.
And you knew that the person had just come out of prison. The one thing that we cannot mention is the Florida Department of Corrections website, or that the defendant had ever been to prison or had just come out of prison. So whenever I ask you questions, I'm really just going to be asking you about October the 23rd of 2003 and the events of that day specifically. Okay?
Okay.
All right. Thank you, sir.
Appreciate that.
Judge, before the jury, since he's already on the stand, before the jury comes in, we renew all objections to the testimony.
Same rules.
Thank you.
All rise, jurors entered.
One other thing, we looked through your thing, you have 6 prior felonies, so if they ask you how many prior felonies you have, 6.
Okay.
Remember that number?
Thank you all. You all may be seated. When you're ready.
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
Could you please state your full name for the record?
Raymond Lee.
And sir, are you currently employed?
Yes.
Where do you work?
At Midwest Transportation.
Okay, and how long have you worked there?
2.5 years.
Okay, so I'd like to turn your attention to the time frame of October the 23rd of 2003 at about 8 p.m. Where were you at around that time on that day?
Home.
Okay. Where did you live?
I don't forget the address, but on Eskimo in
And
Tampa.
That's in here in Hillsborough County, is
Yes.
that correct?
Yes, correct.
Who were you living with?
Me and Elaine Caldwell, my girlfriend.
Okay. Was there anyone else living in the home at the time?
Yes,
Who?
our daughter.
How old was your daughter?
Was
Objection, relevance?
Sustained.
So at the time of October the 23rd of 2003 at 8 p.m., what were you doing at your home?
I was watching television in the den.
Okay. Were you with anyone in the den?
Yes,
Who were you with?
my daughter.
And was Elaine Caldwell home as well?
Yes, she were.
Where was she?
She was in the bedroom doing her hair.
And did something out of the ordinary happen?
Yes.
What happened?
I had someone come into my house that wasn't invited in my house.
And what did the person do?
Well, he came in with a gun. He came in to rob me.
So when this individual came into your home, do you know if he had anything covering his face? Did he have a mask or anything on?
No, he didn't have no mask on. He had a hat on, but he didn't have no mask.
Okay. And did he speak with you? Did he say anything to you?
Yes, he would ask who was all in the house.
And what did you say?
My girlfriend Elaine.
Okay. And at that point, what happened after you said that to him?
He asked me to get up, and me and my daughter got up, and he walked us into the next bedroom where she was at. And once I called her, I say, Linnea, and she,
Objection, hearsay?
Overruled.
You can answer the question.
okay, and she turned around and looked and seen the three of us.
Objection, speculation?
Rephrase the question.
What happened after you entered the room, the bedroom with Elaine Caldwell?
Ronnie attempted to, with the gun, and she started screaming when she saw an uninvited guest behind me with the gun to my head, and she just started screaming hysterical.
And then what happened after that?
And, okay, so when she was screaming hysterical, and I kept telling her to be quiet, and he kept having the gun to my head, and he kept saying, well, where's the money? And she kept screaming, and then he pointed the gun at her, and he kept saying, be quiet, and I kept trying to tell her to be quiet too. And then my daughter was crying also and stuff. And
Objection, relevance?
Overruled.
And my daughter kept screaming, and she was crying and stuff too. And then Ronnie had pointed the gun, and he told her that he wasn't gonna hurt her, and he kissed her on the forehead and said, I'm not gonna hurt you and stuff. So he pointed the gun back at Elaine because she kept screaming and stuff. So what I did was I reached for the gun, and we went to tussling with the gun and stuff like that, and the gun went off. I thought that it shot up in the ceiling, but it hit her in the head.
Okay. Did you see Elaine Caldwell get hit in the head or get shot?
Yes.
And then how did she react after she got shot?
Well, she fell.
Okay. What did the defendant do after that?
Three of us, we all freaked out, you know what I'm saying, that the gun went off in the bedroom and seen her fall and stuff, and he kept saying where the money was, and then my daughter said, it's out there in the car, it's in the trunk, out there in the car and stuff. So he was leading us out, going out the front door and stuff, and once we did get out the front door, I pushed my daughter and I told her to run and stuff, and Ronnie ran down one way and I ran across the street trying to get help.
At some point, did you give Ronny Walker money?
Yes.
Okay. How much did you give him?
Probably about $500 I had in my back pocket.
At what point did you give him this money? Is it before you went into the bedroom with Elaine Caldwell or after?
I can't quite remember, but I think he probably took it before we went in the bedroom with Linnea.
So after Mr., and do you see that person who was in your home and shot Elaine Caldwell in the courtroom today?
Of course I do.
Can you please identify him by an article of clothing?
Yes, right there with the gray suit on with the sunglasses or whatever shades on. Sent to the table right there.
You want
Never
to make the
f-
record reflect that the witness has identified the defendant?
Yes, it will.
Okay. And so, do you know which one happened first in time? Do you remember whether when he entered the home and he asked you for money, whether he ultimately got that money from you before you went into the bedroom?
On a scale from 1 to 10, I give it an 8 that he took it. I gave him the money before we went into the bedroom.
Okay. And do you remember Mr. Ronny Walker still asking for more money?
Oh, of course.
Okay. So tell us what happened at that point.
When we was in the bedroom,
Answer, Judge.
Sustained.
After you gave him the $500, was there a time that he asked for more money?
yes, when we walked into the bedroom. See, he took the money from me while we was in the den.
Okay.
As we was walking to the room where Elaine was doing her hair at, right? That's when he kept asking for more money.
Okay. All right. And after Elaine Caldwell was shot, did he continue to ask for more money?
No.
Did he take you outside for more money?
Right. Yeah, we walked back outside because my daughter had said that it's in the.
Objection, hearsay.
Goes to, okay. You can answer the question.
She said that it was in the trunk of the car. She was saying that to get him
Objection, speculation.
out of the house.
Hold on. Sustained.
And Judge, I'd ask him to strike that.
Strike the last statement.
Did you walk out of the house with Ronny Walker and your daughter?
Yes.
Ask and answer, Judge.
Sustained.
Under what circumstances did you walk out the house, out of your home, after
Ask and
Elaine?
answer, Judge.
May we approach?
I'll overrule that, Judge.
Under what circumstances did you walk out of your home after Elaine Caldwell was shot?
Up under the distress of Ronny Walker with a gun, walking us, we going out the front door.
Did he still have the gun pointed
Of-
at you?
Of course.
At any point during this incident, did Ronny Walker also have the gun pointed at your daughter?
Yes.
Objection, relevance.
Sustained.
It goes to the aggravator, Your Honor.
I'll sustain the objection.
Okay. At any point in time, did Ronny Walker have the gun specifically pointed at Elaine Caldwell?
Yes.
Judge, I would ask that you can answer concerning your daughter and tell the jury to disregard.
May we approach, Your Honor?
No, I'll strike it.
Did you ever give Ronny Walker permission to enter your home?
No, I didn't.
Did you know Ronny Walker before this day, October the 23rd of
No.
2003?
No.
Your Honor, may I have a moment?
Yes, ma'am.
I have no further questions.
Cross?
Good afternoon. So, sir, you've been convicted of 6 felonies, is that correct?
That's correct.
Okay. And you indicated that Mr. Walker, who you've identified as being in your house that day, had kissed your daughter's head and said he was not going to hurt her, correct?
Correct.
Right. And he had said he's not going to hurt her because he has 2 daughters of his own, correct?
Correct.
Right. And you indicated and you told the jury that basically you are tussling with him at some point, and that's when the gun, quote, goes off, correct?
Correct.
All right. And at some point, Mr. Walker tried to get out of the house, didn't he?
Of course, all of us tried to get yes.
Before that, didn't he try to exit the home?
Before that,
Yes, before you walk out to the car with Mr. Walker and your daughter, doesn't he try to get out of the house?
no.
You didn't just tell me that in deposition?
No, when I said what I said was we all was going out of the house, not him trying to get out of the house on his own and leave us in there.
Okay.
We was all going out to the car so-called to get money from out of the trunk of the car.
Okay, understood. So are you denying that you just told me under oath and deposition?
Objection, Your Honor, improper impeachment. May we
Sustained.
approach?
Well, let me ask you this question.
Okay.
And see. Did you in fact just give us a deposition?
Yes, I did.
Improper impeachment.
Overruled.
Did you just give us a deposition?
Yes, I did.
Were you placed under oath at the time? to
Yes,
tell
I
the
were.
truth? Okay, and did you speak with myself and Ms. Fawcett?
Yes, I did.
Right? All right. Let me ask you, did you make the following response to the following question or the following response and tell us that at some point before you walk outside with Mr. Walker and your daughter, Mr. Walker was trying to get out of the house on his own?
Maybe I misunderstood what you were saying.
Everybody.
If I
be
did,
quiet.
if
Hold
I,
on. One at a time. Don't speak over each other, because this young lady right here can't write down 3 conversations that are going on. So there's been an objection, grounds,
Improper impeachment.
overruled.
Okay. All right, and you indicated that Ronnie asked for money, is that right?
that's correct.
And he was asking that several times, right?
That's correct.
Okay. And may I have a moment, Your Honor?
Yes, ma'am.
No other questions. Thank you, Mr. Lee.
Do you read?
No, Your Honor, thank you.
May this witness be excused?
Yes.
Thank you, Susan. Step down. State, you may call your next witness.
Your Honor, at this time, the state would call Ashley Alexander.
Good afternoon. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
While Ms. Alexander is approaching the podium, may Ms. Fawcett and I approach?
Sure, come on up. All right, ladies and gentlemen, once again, I'm going to read you partial part of the original instruction I gave you. Once again, the state is about to present evidence of the existence of an aggravating factor. Victim impact evidence may be presented. Such evidence is only presented to demonstrate Nilexia Alexander's uniqueness as an individual and the loss to the community by the victim's death. However, the victim impact must not be considered by you as an aggravating factor.
Judge, may we approach?
Yes. Once again, ladies and gentlemen, victim impact evidence may be presented. Such evidence is only presented to demonstrate Nilexia Alexander's uniqueness as an individual and the loss to the community by the victim's death. However, victim impact evidence must not be considered by you as an aggravating factor. Thank you. You may proceed.
Thank you. Good afternoon, ma'am.
Good afternoon.
Can you please state your full name for the record?
Ashley Alexander.
And ma'am, how are you related to Nilexia Alexander?
I'm her mother.
Did you prepare a victim impact statement?
Yes, ma'am, I have.
Are you prepared to read it?
Yes, ma'am, I am.
Okay. She may
You may,
proceed.
whenever you're ready, ma'am.
My name is Ashley Alexander. I am the mother of Nilexia Alexander. I became Nilexia's, which we call her Lexi, foster mom, June of 2011. I remember when Lexi came to my home, she was a fragile little girl who was scared and nervous, but she became warm with love. She opened up as she got more comfortable in my home. Lexi was my gentle giant. She was sweet, loving, and caring. She gave the best hugs and kisses. My baby was always smiling. She wasn't confrontational with anyone. If you asked her for a shirt off her back, she would give it to you without hesitation. Lexi was always loving, outgoing, and she was always wanted to do anything to help everyone that she could. The past 2 years having the girls, I grew very fond of Nilexia and her sister. So in April 2013, I decided to adopt Lexi and her sister. Not only because I love the girls, but because I wanted them to have a forever home. We always did fun things such as picnics, going to the beach, and of course the pool every weekend. Lex loved water. Lex loved helping in the kitchen, cooking, and preparing meals for our dinner movie nights. When she was younger, Lex and her sister and I would always sit in a room and watch a Disney movie. Frozen, Monster High was our favorite. She loved Shopkins, and for Christmas, she always told me, Mom, I want all Shopkins, everything. So I would take the girls to my mom's house later at night just to go out looking for Shopkins in the store. I went from Walmart to Toys R Us, Target, and Ross. Wherever they had kids' toys, I was there. As Lexi grew older, I had to learn to adjust and grow and change with her personality. As she became a preteen, she got into the different hairstyles, different music types. She loved to dance, sing, and dress up. Lexi had dreams of becoming a fashion designer. She wanted to graduate high school and go to college in New York City. She wanted to study fashion. She also wanted to study to be a lawyer. For her 15th birthday, my mom and I were going to surprise her with a trip to the Big Apple, as she could see her dreams can come true and get the experience of traveling on a plane, something she always dreamed of. I miss the conversations. I miss sitting on the porch talking about her school days and talk about the school dances that were coming up and how she wanted her hair done and the dresses she wanted to wear. I miss listening to her dreams and all her desires. I miss her climbing in my bed and wanting her hair rubbed as she fell asleep in my lap. I thank God for allowing me to be Nilexia's mom for the 12 years.
Thank you, ma'am. Showing you what has been pre-marked as City Exhibit 4A through J, do you recognize these photographs?
Yes, ma'am, I do.
Are there an accurate depiction of Nilexia?
Yes, ma'am, it is.
Your Honor, at this time, the state would move into evidence State Exhibit 4A through J.
Same objections, Judge.
Same rule, I'll allow it.
Publishing, State A through J. State Exhibit 4A. Ma'am?
Yes,
You
ma'am.
look that way, or? Is this Nilexia?
Yes, ma'am.
Do you remember what was happening at this point?
That was her 4th birthday. It was at Chili's celebrating.
State Exhibit 4B.
First day of kindergarten.
4C.
Christmas, I want to say she was about 11, 12. It was at my mom's house.
Did you put these enhancements?
I did, from
Okay.
Snapchat.
State Exhibit 4D.
We was going shopping. She was about 13 here.
And did Nilexia put these enhancements?
Yes, ma'am. She always had my phone on Snapchat.
Okay. State Exhibit 4E.
She was actually 10 on this picture at She High Elementary. She was in 5th grade. She was a patrol.
State Exhibit 4F.
She was about 7, and we was all going out to dinner.
State Exhibit 4G.
That was Christmas of 2021, and she was 13.
State Exhibit 4H.
She was 12 on this picture.
State Exhibit 4I.
Her 5th grade banquet at She High. That was her 5th grade banquet at She High.
Okay. And State Exhibit 4J.
That was just one Sunday, was at my mom's house, sitting at the table, and my mom was making a joke, and she just turned around and had this smile on her face, and it was a moment to catch her. And she was about 11, 12.
Okay. Thank you, ma'am. You're not.
Oh my
quite.
God, I'm sorry.
We have no questions.
Okay.
Oh, I'm sorry.
All right. Thank you.
State, next witness.
Yes, the state would call Nilexia Alexander.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I do solemnly affirm.
Thank you. Good afternoon, ma'am.
Good afternoon.
Can you please state your full name for the record?
Nilexia Alexander.
Okay. And how do you know Nilexia Alexander? How did you know her?
She's my granddaughter.
Okay. And under what circumstances did she become your granddaughter?
When my daughter started, she fostered her, and then we all fell in love with her, and then she decided to adopt them.
Okay. And if you could get closer to the microphone. Did you spend a lot of time with Nilexia Alexander?
I did,
Okay. Did you create a victim impact statement?
yes,
Are you prepared to read it?
yes.
Okay, thank you.
My name is Nilexia Alexander. I am the mother of Nilexia Alexander. Friday, May 6, 2022 is a day that I will forever be etched in my memory. I was on my way to dinner with friends when I received the call that Nilexia was dead. My first thought was that there must have been some kind of mistake. I could not believe, but it was true. Nilexia, or Lexi, as we lovingly call her, was a social butterfly and a girly girl. She loved getting her hair, nails, and toes done. From the age of 5 to 8, she and her sister would spend weekends with me because their mother worked every weekend. We would start our mornings with her favorite breakfast: waffles, eggs, grits with cheese, bacon, sausage, and fresh fruit, which she loved having to prepare. We would sit out on the lanai, eat and talk. Then we would begin our manicures and pedicures. She and her sister would pick their favorite colors, and I would polish their nails and add a design of their choice. If I were having a difficult day, Nilexia would say, "Nana, I know what we can do to cheer you up." When I asked her what, she would say, "Shopping." So off we go to our favorite stores: Dillard's, Nordstrom's, and Macy's. Lexi always talked about going to New York. We were planning to surprise her with a trip for her 15th birthday. Sadly, we never had the chance. She was such a loving and beautiful child, and her absence has left a hole in our hearts that can never be filled. One of Nilexia's favorite hobbies was baking cookies. She especially loved baking chocolate chip cookies. I remember how excited she would get gathering all the ingredients. She took pride in measuring everything perfectly and always insisted on taste testing the dough. The kitchen would fill with the sweet smell of cookies, and she would light up with joy when they came out of the oven. Baking together became one of our special traditions, and those moments are now some of my most cherished memories. Nilexia loved to dance to her favorite song, "Girl on Fire" by Alicia Keys. Even though she had no rhythm, but she was having fun like any typical teenager. She will forever be in our hearts and deeply missed.
Thank you, ma'am. Thank you.
I don't know questions.
Thank you. Yes, the state would call Miss Gatson Yarborough.
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am.
Councilman, are you ready?
Thank you. Could you please state your full name for the record?
Delia Gadsden Yarbrough.
Okay. And ma'am, are you currently employed?
Yes, I am.
Where do you work?
Hillsborough County Public Schools. I was the principal at Shehigh, and next week I'll be the principal of Muller.
Congratulations.
Thank you.
Okay. Do you know Nilexia, did you know Nilexia Alexander?
Yes, I did.
How did you get to know her?
She was a fifth grade student, my first year as principal at Shehigh.
Did you prepare a victim impact statement?
Yes, I did.
Are you prepared to read it?
Yes.
Thank you.
As the principal of Shehigh Elementary during the 2018-2019 school year, I had the privilege of knowing Nilexia Alexander, a remarkable fifth grade student we all called Lexi. She was a dedicated safety patrol and had a heart for helping others. She loved helping her teachers and younger students. She was a bright, kind-hearted girl who always proudly wore her patrol belt. I remember her enjoying all of the end-of-the-year fifth grade festivities, especially getting dressed up for our awards luncheon in a pretty purple dress. I also remember how excited she was to ride in my car to the annual patrol luncheon we hold at Big John's Barbecue every year. I remember how she giggled and laughed when she was talking with her friends. She was happy and enjoyed school. One memory that remains etched in my heart is the day she surprised us after she had moved on to Sly Middle School. She walked in the blazing heat all the way back to Shehigh just to say she missed us and to see all of us. I remember seeing her come up to the car line, hot, tired, and flustered, but beaming. That small act spoke volumes about the love she carried in her heart, even at such a young age. She longed for connection. Tonight, my mind is flooded with images of this beautiful, bright child that would be preparing for her senior year of high school this summer. She will never get to experience high school, prom, graduation, and beyond. In my 29 years as an educator in this community, I've had the privilege of working with thousands of students over the years. Some stand out more than others, but Lexi was truly special. She was always so caring and wanted to be a part of our school even after she moved on. Her smile could light up a room, her laugh was contagious, and her voice was full of kindness. I will never forget Lexi. She will always have a special place in my heart. Her memory will forever remind us of the love and joy she brought into our lives. Respectfully, Lexi's elementary school principal.
Thank you, ma'am.
Thank you.
Thank you.
Thank you, ma'am. All right. Dave, come on up. Terry, whenever you're ready.
Yes, Judge. At this time, we would move in all the evidence that was obtained in the guilt phase into the this penalty phase, Your Honor. And with that, we will rest.
Other than previous objections, any other objections?
Same objections made during the guilt phase by Ms. Tucker and Ms.
Same rulings that will be all admitted. And state?
Judge, at this point, we rest our penalty phase.
All right, ladies and gentlemen, before I recess for the day and ask you to come back tomorrow at 8:30, I want to remind you that even though there were two judgments that you saw, it was just from one case, and Mr. Walker pled guilty to both of those judgments in that one case. Anything else? All right, court being recessed till tomorrow morning at 8:30.
All rise. You can get your notes.
Jury's left, y'all may be seated. Any matters we need to discuss outside the presence of the jury?
I believe so, Judge.
All right, we'll see you folks tomorrow morning at 8:30. Court's in recess.
Court stands in recess. Please exit